Hi, and welcome to this latest immigration law update video. This is the fifth video in my series looking at the reported decisions of the Upper Tribunal for 2020. And in this video, we're going to look at the decisions for May 2020. And there are three decisions on Bailey, although all three are important ones. There's a country guidance decision on the safety of Kabul and internal relocation. There's a case on the Secretary of State's disclosure duties in terms of her policies. And also there's an important JR challenge in terms of the Secretary of State's fee waiver guidance. As usual, I've put the links for these cases below this video, and I'll put my slides on the Number 8 Chambers website. So let's have a look at these three cases for May 2020. And the first one is CAS Safety of Carbul, and it's number 130 in the reported series for 2020. And this is the case that was remitted back from the Court of Appeal because of the previous statistical error by the Upper Tribunal. It's important actually to have a look at this case, not just the head note, because the judgment itself looks at the expert evidence and accepts the expert evidence of Dr. Schuster in terms of his country evidence, and Dr. Ahmad, who looks at the mental health evidence and the effect on somebody's mental health of going back to a conflict zone, which, as we're going to see, will be likely to be an important consideration when arguing about the reasonableness of internal relocation to Kabul. The overall conclusions of the Upper Tribunal are at paragraph 252 of the judgment. So a person who's of low-level interest to the Taliban is not at a real risk of persecution from the Taliban in Kabul. That's point one. Point two, there is widespread and persistent conflict-related violence in Kabul, but somebody's not going to be qualifying for humanitarian protection just because of that indiscriminate violence, point two. So what about the meat of the decision? And that's the reasonableness of internal relocation. So let's have a look at point three. Having regard to the security and humanitarian situation in Kabul, as well as the difficulties faced by the population living there, primarily the urban poor, but also IDPs and other returnees, which are not dissimilar to the conditions faced throughout many other parts of Afghanistan, it will not, in general, be unreasonable or unduly harsh for a single adult male in good health to relocate to Kabul, even if he does not have any specific connections or support network in Kabul, and even if he does not have a tazkira. So in general, for a single adult male in good health, they can relocate to Kabul, even if they don't have connections, a support network, or that important identity document, the tazkira. But the individual circumstances must be considered in every case. So let's have a look at Roman 4 and see how we can find a way into successfully arguing against relocation to Kabul. So Roman 4, however, the particular circumstances of an individual applicant must be taken into account in the context of conditions in the place of relocation. And let's have a look at the factors we've got to look at, including a person's age, nature and quality of support network connections with Kabul/Afghanistan, their physical and mental health, we'll come back to that, and their language, education and vocational skills when determining whether a person falls within the general position set out above. Given the limited options for employment, capability to undertake manual work may be relevant. Because actually a lot of people who's not got connections or an identity document, the tribunal find that they're going to end up working in the informal economy as a day labourer. So we need to be able to ascertain whether they would be able to do that. So physical and mental health is very important. So you're going to need good medico-legal evidence in presenting your case. And it's not just the mental health in terms of somebody's mental health now, but also their mental health and the effect of going to live in a conflict zone such as Kabul. And Dr. Ahmed, in her evidence, stresses this and the prevalence of mental health difficulties in Afghanistan. So have a look at that. Roman 5, a person with a support network or specific connections in Kabul is likely to be in a more advantageous position on return, which may counter a particular vulnerability of an individual on return. A person without a support network may be able to develop one following return. A person's familiarity with the cultural and societal norms of Afghanistan, brackets, which may be affected by the age at which he left the country and his length of residence, close brackets, will be relevant to whether, and if so, how quickly and successfully he will be able to build a network. So their familiarity with the culture and societal norms of Afghanistan is important. And one key relevant factor is the age in which they lived Afghanistan and the length of time they've been away from there. Because often in Afghani cases, the appellant may have left Afghanistan as a minor. They would have grown up and gone through their secondary education in the United Kingdom. So they would have little understanding of the societal and cultural norms there, having not lived there as an adult, not been in the workforce before, maybe never been to Kabul before. And most of their life would have been, and their connections and their identity would have been formed in the United Kingdom. So those are important things to stress when arguing the reasonableness of relocation. I think these factors also are relevant to an argument under 276 ADE Roman 6 and arguing the case that there are very significant obstacles to integration, because that's often worth arguing as a sort of backup point behind an asylum claim. The final parts of the head note is saying which country guidance cases are still good law and are unaffected by this decision. Look at Roman 7, particularly in relation to certain categories of women which remain unaffected by this decision. Let's move on to the second case, and that's BH, which is about policies and information and the Secretary of State's duty. This was a challenge to a refusal of an appeal, and it went to the upper tribunal on the failure of the Secretary of State to disclose their CPIN on Iraq. CPIN stands for Country Policy and Information Note. Let's have a look at the head note, and I'll explain it as we go. And I've done a separate video on this case. You can have a look on my channel for that. Firstly, the Secretary of State has a duty to reach decisions that are in accordance with her policies in the immigration field. So it's a public law duty to make decisions in accordance with current extant policy. We know that from Supreme Court cases such as Lumba and Mandalia. Where there appears to be a policy that is not otherwise apparent and which may throw doubt on the Secretary of State's case before the tribunal, she is under a duty to make the relevant policy known to the tribunal, whether or not the policy is published and so available in the public domain. So if there's a policy that's not favourable to the Secretary of State's case, whether or not it's a published policy, she must disclose it to the tribunal. And note what's said: despite their expertise, immigration judges can't be expected to know all and each and every of the Secretary of State's policies, which are many, as we know. Now, they draw a distinction in this case between policy and information. So it says this: in protection appeals, and probably in other kinds of immigration appeals, the Secretary of State has a duty not to mislead, which requires her to draw attention to documents, etc., under her control or in the possession of another government department, which are not in the public domain and which she knows or ought to know undermine or qualify her case. So the tribunal, and it's a presidential panel, looks at the case of Karush and the case of UB Sri Lanka. And they say where we're looking at just information documents, which are not policy, there's a duty not to mislead, and those are to be drawn to the attention of the tribunal where they are not in the public domain. Where they are in the public domain, there's no need. So there's a distinction between policy documents, which must be disclosed whether or not they're in the public domain, and merely information documents. So C, there is a clear distinction between information and policy. The fact that country information is contained in a COI document published by the Secretary of State does not without more make that information subject to the duty in subparagraph A above. So just because something's called a CPIN, which has the word policy in it, doesn't mean it's actually policy. It may be just information. And if it's just information, which is in the public domain, the Secretary of State doesn't have any duty there. If there's something that undermines her case that is information that's not in the public domain, then she has to bring it to the attention of the tribunal. And of course, there's this higher duty with policy, which, if it's unfavorable to her case, must be disclosed, whether in the public domain or not. So that's BH. Finally, then, Dzineku-Liggison, which is on the fee waiver guidance. We know one of the important planks of the Secretary of State's hostile environment is these ever increasing application fees, which, when combined with the health surcharge, make it very difficult for people to regularize their status in the United Kingdom because of the whole issue of the affordability of making an application. Now, in cases that had gone previously, a case called Omar and a case called Carter, the appropriate test in terms of fee waiver was affordability, whether an applicant could afford the test. Afford the fee. But the test in the Secretary of State's guidance, version 3, was actually set out in terms of the destitution, the threat of destitution, and exceptional circumstances. So in this case, Upper Tribunal Judge Blundell, and you'll see the Home Office, you'll see the head note there, said the Secretary of State's fee waiver guidance, version 3, was unlawful because it failed to properly reflect the settled test of whether the applicant is able to afford the fee. And I've set out two extracts from the judgment. Paragraph 89, I come to the clear conclusion that the overall effect of the guidance is to circumscribe unduly the circumstances in which an individual might qualify for a fee waiver. The underlying affordability test is not expressly mentioned. The structure of pages 13 and 14 is confused and confusing. The guidance is dominated by reference to destitution, which further obscures the relevant test. The analysis required by the third stage impermissibly erects an exceptional circumstances hurdle. A reasonable and literate person applying the guidance would understand the three stages to be focused on destitution, the threat of destitution, and the existence of exceptional circumstances. So the guidance was unlawful because it failed to apply that affordability test. But the judgment goes on because it actually finds the underlying substantive decision irrational also. So Upper Tribunal Judge Blundell says at paragraph 94, the evidence which had been presented was sufficient on any rational view to establish that the applicants were unable to pay a combined application fee of nearly £8,000 from their own resources. So this judgment is helpful at looking at the substantive decision on the fee waiver application. Actually, in paragraph 95, Judge Blundell looks at the ability to get a loan, which is often an issue raised by the Secretary of State. Now, permission to appeal to the Court of Appeal has been granted, so we'll have to see what happens in respect of this. But the Secretary of State has amended her fee waiver guidance in June of this year, and what she's done is bolted on the affordability test. So the reference to exceptionality and destitution is still there, but she's also added the affordability test. So we'll have to see what happens. But this case is really helpful in terms of the correct approach and the correct test in law, but also the substantive JR in terms of the challenge to the decision in the individual case. So those are the reported decisions for May 2020. I hope this video has been helpful. As I said, the slides will be on the Number 8 Chambers website. I'll put the links to these cases below the video in the description, and I'll hopefully see you soon when we'll look at the reported decisions for June 2020. Thanks a lot.